Good afternoon. Good afternoon, everyone. Please finish with your desserts. I want to welcome you all to our 11th annual Rosenkranz debate. I want to express our gratitude to the Rosenkranz Foundation for supporting this event for the last decade. We love having this Saturday centerpiece for our convention, an intellectually sharp, one-on-one debate between two highly prominent legal theorists. It's been quite a distinguished career, which had a wonderful start in 2008 with a discussion between judges Richard Posner and Mike McConnell, then judges Guido Calabresi and Frank Easterbrook. In 2010, Professors Richard Epstein and William Eskridge. In 2011, Paul Clement and Larry Tribe debated healthcare. In 2012, we had Judge Kaczynski and Hadley Arkes. In 2013, Randy Barnett and Judge Wilkinson. In 2014, former Attorney General McCasey debated Nadine Strawson. In 2015, Robbie George and John McGinnis debated "The Constitution was made for a moral and religious people and is indeed suited for the government of no other." In 2016, we had Professors Eugene Volokh and Deborah Rohde, and last year, Randy Barnett and Katyal Amar debated. To moderate this year's debate and introduce our speakers, I want to call on Assistant Attorney General for the Office of Legal Policy, Beth Williams, who's long been involved with the Federalist Society. Beth?
Thank you. Well, thank you so much, Jean, for that introduction, and thank you all for the warm welcome. I also want to thank Jean, Leonard, Dean, and the team at the Federalist Society for putting on a characteristically fantastic conference these past few days. And thank you, of course, to Professor Nick Rosenkranz for starting and continuing the wonderful tradition of this debate, which follows in the best tradition of the Federalist Society of exploring opposing views on timely and important legal topics. I'm honored to be here today to moderate today's Rosenkranz debate, which will take on a very timely and important topic, whether lower courts have the authority to enter universal injunctions. Before I introduce our debaters, I'll take a few minutes to set the stage. Universal injunctions are injunctions that grant relief to parties outside the case and outside of the class action framework. One question that recurs has been, what do we call them? Many have called them nationwide injunctions, but that name is not really appropriate because it's not the geographic scope that defines them. Their defining characteristic is who gets the relief afforded. Is it just the parties to the case, or are parties beyond the case granted relief by the court? So we've thrown around various names for them: limitless injunctions, non-party injunctions. Justice Gorsuch recently at oral argument suggested they could be called cosmic injunctions. And of course, at the Department of Justice, we call them every other Friday injunctions. But regardless of what they're called, the entry of universal injunctions is a relatively recent phenomenon. Universal injunctions did not exist before even 60 years ago. Before 1963, no court in this country had issued such an injunction, and they were very rare until President Reagan took office. Even after that, by Department of Justice estimates, courts issued an average of only 1.5 universal injunctions per year against the Reagan, Clinton, and George W. Bush administrations, and 2.5 per year against the Obama administration. In President Trump's first year in office, however, judges issued a whopping 20 universal injunctions, an 8-fold increase over the last administration. This matches the entire 8-year total of such injunctions issued against President Obama during his 2 terms. We are now at 27. Whatever you might think about the merits of universal injunctions, the sharp increase in their frequency is remarkable. In full disclosure, the Justice Department's position on this is not a secret. Over the years, the department, including under President Obama, has taken a consistent position on them. And my office, the Office of Legal Policy, has had the opportunity to delve deeply into the issue. In fact, earlier this fall, Attorney General Sessions issued litigation guidelines for Department of Justice attorneys involved in litigation that challenges a federal government program, regulation, order, or law. But I know this is making news. Not everyone agrees with the Department of Justice. Some question whether the judiciary can really be an effective check on presidential power and unconstitutional statutes if lower courts do not have the power to strike down unlawful actions immediately and universally. Many people on both sides of the aisle believe that lower courts must have this power in order to best preserve liberty. I'm happy to be in the moderator's chair for what I know will be a robust and terrific debate between two great legal minds, Professor John Harrison and Mr. Neal Katyal, on the question whether district courts have the authority to enter universal injunctions. Let me introduce them. Professor John Harrison is the James Madison Distinguished Professor of Law at the University of Virginia School of Law. He joined the faculty in 1993 as an associate professor of law after a distinguished career with the Department of Justice. His teaching subjects include constitutional history, federal courts, remedies, corporations, civil procedure, legislation, and property. In 2008, he was on leave from the law school to serve as counselor on international law in the Office of the Legal Advisor at the U.S. Department of State. A 1977 graduate of the University of Virginia, Professor Harrison earned his law degree in 1980 at Yale, where he served as editor of the Yale Law Journal and editor and articles editor of the Yale Studies in World Public Order. He was an associate at Patton Boggs and Blow in Washington, D.C., and clerked for Judge Robert Bork on the U.S. Court of Appeals for the District of Columbia Circuit. He worked with the Department of Justice from 1983 to 93, serving in numerous capacities, including Deputy Assistant Attorney General in the Office of Legal Counsel from 1990 to 1993. Neal Katyal, on my left, is a former acting Solicitor General of the United States and is now a partner at Hogan, Lovells, U.S., LLP, focusing on appellate and complex litigation. He has extensive experience in matters of patent, constitutional, technology, securities, criminal, employment, and tribal law. In December 2017, American Lawyer magazine named him the Litigator of the Year. He has already argued more Supreme Court cases, 37, than any other minority attorney in U.S. history, recently breaking the record held by Justice Thurgood Marshall. Prior to joining Hogan Lovells, Neal served as acting Solicitor General of the United States. In 2011, he received the highest award given to a civilian by the U.S. Department of Justice, the Edmund Randolph Award. Earlier in his career, he served in the Deputy Attorney General's office at the Justice Department as National Security Advisor and as Special Assistant to the Deputy Attorney General during 1998 to 99. Neal has also served as a law professor for over 2 decades at Georgetown University Law Center and has been a visiting professor at both Harvard and Yale Law Schools. After graduating from Yale Law School, Neal clerked for the Honorable Guido Calabrese of the U.S. Court of Appeals for the Second Circuit, as well as for the Honorable Justice Stephen G. Breyer of the United States Supreme Court. I will also mention one last fun fact. Neal has played himself arguing a Supreme Court case against the Solicitor General in an episode of House of Cards on Netflix. It's fantastic. Which means you can find him not only in the Supreme Court Reporters, but also on imdb.com. Both John and Neal have given careful and sustained consideration to the question at hand. John, particularly through the lens of his academic work on the structural requirements in the Constitution, among other topics, and Neal most notably through his role as counsel of record for the respondents in Trump versus Hawaii, which presented the issue of the proper scope of relief at every level, including at the Supreme Court. I know they will both have a lot to say on this. The structure of this debate is that each will give an opening statement of about 12 minutes, followed by a second round of 7 minutes each. Then we'll move into some back and forth discussion. Professor Harrison, please start us off.
Thank you. I'm afraid I'm not to be found on Netflix, so this is a Federalist Society exclusive. I have 3.5 things to say, and I will admit one of them is basically something I said at the very first Federalist Society event I participated in 1986. And Grant Gilmore said of Christopher Columbus Langdell, dean of the Harvard Law School, that he had one idea, and he clung to it with a tenacity of genius. I will at least claim tenacity on this. The first thing I will say is that it is intrinsic in the idea of a case or controversy, but case is the broader concept, so I'll use that one, under Article 3, that the case is about the relation between parties and hence the remedial authority of the court extends only to vindicating the rights of the plaintiff. That's as far as it goes. That's one of those principles that is so basic that you are more likely to find traces or manifestations of it than straightforward statements of it, so I'll mention a couple of traces or manifestations of it. One, description of what a case is by John Marshall in Osborne against the Bank of the United States. That power, he said, referring to the judicial power, is capable of acting only when the subject is submitted to it by a party who asserts his rights in the form prescribed by law. That's what a case is. It's about the relationship between parties, and remedies go to parties. Another manifestation of that is today's Supreme Court standing doctrine. There's a lot to criticize in the standing doctrine, but one of its fundamentals, I think, is well-founded. The reason private parties have to rely on private injury and can't rely simply on the fact that some law is not being complied with is because the right to demand compliance with the law just by itself belongs to another party. It belongs to the public, and parties can assert only their own rights, not those of others. Another manifestation of this, and I think this is especially interesting because this is a place where you might find a manifestation of sort of what you might think of as the counter principle. I'm going to find it in the Declaratory Judgment Act. And frequently, the Declaratory Judgment Act is thought of as the source of the ability just to say, for example, that a statute is unconstitutional. The Declaratory Judgment Act, though, says that the courts may, in a declaratory judgment, in a case of actual controversy, declare the rights and other legal relations of any interested party. Legal relations, including rights, connect parties to one another. That relational idea of law, that relational idea in particular of litigation, was behind the Declaratory Judgment Act. It was well known to people at the time that act was being adopted, like, for example, Judge Cardozo in Palsgraf, who asked not, was there negligence, but was the Long Island Railroad had the Long Island Railroad created an unreasonable risk to Mrs. Palsgraf? Law and litigation are inherently relational. At least that's the way I see it. I'm a law professor. I like nice, clean concepts. History is a little messier than nice, clean concepts. And probably the most important reason to think that maybe the powers of the federal courts, the concept of the case, goes beyond just acting as to the party is equity practice back before the framing of the Constitution and ever since, in which equity courts sometimes gave and continue to give relief to parties who are not exactly before the court. And when I say not exactly, I want to stress that the primary manifestation of this in the old days in equity was what was called the Bill of Peace, in which one party or a number of parties could sue a wrongdoer who was doing something that affected a great many people and obtain relief that would benefit all the people involved. The important thing to understand about bills of peace is that they were understood as representative actions. That is to say, the reason one party or a limited number of parties could seek relief on behalf of others was because they stood in for those others. So the concept of a case does include representation. It does include some form of indirect litigation, but there has to be representation. And today, of course, the manifestation of that principle is the class action. Congress and the Supreme Court and the federal rules have prescribed the means by which one party can represent another. Those requirements are sometimes reasonably demanding, as they ought to be. To say that one party can say, I am here for someone else, is a major step when you understand the idea that lawsuits are relational. And so the limitations of the class action are there appropriately. That's point number one. Cases are about relations between parties. Remedies go to parties. Point two, this is the one that I said in 1986 and just can't get away from. It is often said that the reason it's okay to have universal or even, what's the next step up beyond universal? I guess it's cosmic. Cosmic, man. The justification for the transuniversal injunction is sometimes the idea that courts can, as it said, invalidate or strike down statutory rules or actions of the executive. That is a mistake. Courts decide cases. What I'm about to say is the logic of Marbury against Madison. Courts decide cases. Between parties, give relief to parties. In order to decide cases, courts must identify the legal rules that apply. Because of the American legal hierarchy, they have to consider the possibility that lower-level rules are invalid because they conflict with a higher-level rule. It could be a statute conflicting with a constitution. It could be a regulation conflicting with a statute. That inquiry takes place before the court applies the law as it has identified the law to the parties, and before it then gives any appropriate remedy. That is to say, this inquiry into the law is prior to what the court actually does, which acts on the rights and relations of the parties, not on the law in the abstract. And that is true, and it's especially important to see this, that is true even when the argument that is presented to the court is that some legal rule, some act of the executive is, as we say, facially invalid, is wholly invalid, is invalid in all of its applications. And I'm glad to be able to talk about this at the Rosenkranz debate because Nick Rosenkranz has done fundamental scholarship on just this point, elaborating the situations in which subconstitutional law is invalid at the level of a rule, which is frequently what the Constitution does. It makes whole rules invalid. But even when that's happening, what is still going on is the court is identifying the law at the step identified in Marbury prior to that of applying the law to the particular case, prior to the law of actually doing anything, and so striking down the law is a serious misnomer. There are a number of ways in which it's possible to get confused on this point. One that's of great practical importance is courts do not change law. They identify law, and then they change the relations of parties. The Supreme Court of the United States, in particular, functionally speaking, can do something that's a lot like changing the law because the Supreme Court sets precedents that govern the entire American judicial system. When the Supreme Court says that some law is unconstitutional at the level of a rule, it has done something a great deal like invalidating the law, but it has done something like invalidating the law. One of the things that law professors often debate, talking about the role of the courts, is how important are the law, what's called the law declaring function, the sort of thing I just described, and the case deciding function. My position, and by no means everyone holds this, but I certainly do so quite strongly, is that the law declaring function is based entirely on the case deciding function. And I will assert the same thing about the function of checking the other branches of government. Yes, the courts do that, but they do it by deciding cases and only by deciding cases. So my advice to the courts when they talk about their role in checking the other branches and striking down statutes and so forth is the first thing to know if you're going to be in the business of power is don't believe your own propaganda. Rather, the appropriate way to understand what goes on in a constitutional case is, for example, United States against Eichmann, case about the flag burning statute. The Supreme Court concluded that that statute, following Nick Rosenkranz's logic, that they didn't know that yet, but that's what they were doing, that that statute was wholly invalid. And then, to apply it to that case, they said, and therefore, Eichmann can't be convicted. The actual case-deciding part was about Eichmann. And the same thing would have been true, and this is the transition to point 3, the same thing would have been true if instead of the case being United States against Eichmann, a criminal prosecution, it had been Eichmann against the Attorney General, Eichmann against the enforcing officer. Suppose that Eichmann, the person who protests a lot, says, I plan to protest next week, but there's the flag-burning statute. I want an injunction against the enforcement against me of the flag-burning statute. The appropriate relief, given the facial invalidity of the statute, would have been an injunction as to prosecution against Eichmann. And that's the nice and simple situation. There are also more complicated situations, and they are genuinely interesting, and the Texas and Hawaii cases are examples of more complicated situations. They present a combination of two issues that can arise in equity. The first is what's sometimes called indivisible relief. An indivisible relief arises when there's something a defendant is doing that is wrongful as to more than one potential plaintiff, and where giving relief to one plaintiff necessarily means giving that relief to everybody else. For example, say one neighbor is making an excessive amount of noise and it constitutes a nuisance. Well, say the neighbor on the south side, the sort of person who says, hey, you kids, get off my lawn, sues and gets an injunction against the noise. That will have an effect on the neighbor on the north side, this is indivisible relief, even though the neighbor on the north side may really like the music and think, this is saving me having to buy a sound system. That's indivisible relief. Equity courts do it. It happens. My half point is that may be what's happening when the DC Circuit, as they say, vacates entire regulations under the APA, the Hobbs Act. I'm just going to identify that, pass on from that, and continue with this. With the other complicating factor. 1, indivisible relief. 2, overbroad injunctions. That is to say, injunctions that are designed to get more than the conduct by the defendant that is unlawful, or more than the conduct by the defendant that harms the plaintiff, on the grounds that sorting out the various things the defendant is doing is too difficult. And the appropriate way to get relief for the plaintiff is to draw the overbroad injunction. That was, for example, what Texas asked for in the DACA case. Texas said DACA is wholly unlawful, and beneficiaries of DACA come to Texas and inflict costs on Texas. Hawaii said something quite similar in the Hawaii case. Now, not everybody who was a beneficiary of DACA was in fact going to go to Texas. Some people are so benighted that they never make it to Texas. Similarly, not everyone who was kept out by the immigration orders were going to go to Hawaii. The argument was, can't tell them apart, give the overbroad relief, and the effect will be indivisible relief. That's how the two come together. When a court decides whether to grant overbroad relief, one of the things it considers is the extent of the burden on the defendant and whether it's justified. Because overbroad relief tells the defendant you can't do something that is either not unlawful or at least not harmful to the plaintiff. The thing I want to add to that analysis, and courts have to do this when they're asked for this kind of relief, is to suggest they should also weigh against overbroad relief the interest of potential plaintiffs who have decided or may have decided not to sue. That's very much on display in the Texas DACA case, where a number of states of the union said this program is lawful and it benefits us. We think it is a good thing. Situations like that combine indivisible relief, where there are other potential plaintiffs, and the overbroad injunction are situations where there's a very important interest, the interest in the potential plaintiff who doesn't want to sue, like the neighbor who likes the noise, that the equity courts should undertake to protect. And that's a situation in some of these cases, and I think the DACA case from Texas is an example, in which although geography isn't what this is mainly about, it's about universality, it's about cosmicness, maybe a geographical limitation would be one way to limit the overbroad injunction in the interest of the potential plaintiffs who did not want to sue. My larger point, and I wish I could say that I'm announcing a new maxim of equity, I don't think it's really that good, is that that interest of those other potential plaintiffs who don't want to sue, who may think this isn't a harm at all, is a very serious interest that the court should take it into account in creating what they understand to be overbroad injunctions. And thinking about that, I'll just close by saying here, Neal and I are working on a Saturday. And there's a lot to be said, of course, for just taking Saturday off. And one of the great things about the interest in not being a plaintiff is that it's an interest that can be exercised by doing nothing, by just taking the day off. That doesn't make it an unimportant interest. On the contrary, it's a very important interest. And to take it into account, give less indivisible relief than otherwise might be given, it seems to me to be good equity.
Good. Thank you. Okay. Thank you, Mr. Katyal.
So first of all, it is just great to be here with all of you. The Federalist Society is, I think, the only organization whose invitation I accept every single year, and I do so for one reason, which is its unparalleled commitment to public debate, and hopefully what you see today is going to be part of that. But literally, I've come every year for over a decade now. Well, actually, I missed last year because I had an oral argument, but you probably didn't notice because Gene appointed an acting in my place. You know, that temporary person is going to, be here for at least a year. It's also great because this bears the name of my dear friend Nick Rosenkranz and colleague at Georgetown, so it's a particular privilege. So I am here to defend the stalwart liberal Jeffrey Sessions, who believed in nationwide injunctions until he didn't. He was for it until he was against it. And the argument is based on the text and structure and history of Article 3, and as well as policy arguments. And what I'm going to do is defend what he did, which is, look, nationwide or cosmic injunctions aren't always appropriate. By no means. They should be rare. But in rare circumstances, they are permissible, and they should be rare. But the one question is, if you don't have them, what is the alternative? A litigant could only seek relief in the district court. The district court, what happens when that case goes to the circuit court? Will the circuit court announce a rule that only binds the party, not anyone else, so then everyone else has to bring a case? What happens when the case gets to the Supreme Court? And the fundamental thesis here is that if courts lose this rare tool that they use, they'll lose a significant ability to counter things actions by the other branches that incur on our individual rights and are inconsistent with limited government. And sometimes nationwide injunctions are the only way to police those things. So, I think the story here starts actually with Hammer versus Dagenhart in, 1918, 100 years ago, in which a group of corporations challenged that child labor statute, and the district judge held the law unconstitutional and issued an injunction, but that injunction did not apply just to the parties. It applied to everyone around. And that, I think, is the first example that we've been able to find. I think Samuel Bray, in his article, was able to identify. And I think that kind of way of thinking does follow from older practice. I think the Supreme Court in the Grupo Mexicano case said, when you're thinking about the contours of the Article 3 power, you look to what courts in equity did. And courts in equity, as Professor Harrison has just said, did provide relief in bills of peace. And the most important point about bills of peace is that they were not limited just to the parties before them. They extended more broadly. Now, Professor Harrison said, yes, but those are representation cases. The litigant was always asserting his own rights, and he quoted the Chief Justice Marshall's opinion in Osborne about litigants asserting their own rights. Absolutely. I'm not defending the proposition that a litigant can come in without a claim and say, well, some other dude has a claim in some other jurisdiction, and therefore I have standing to sue and a cause of action on the merits. Of course not. I'm defending the proposition in cases like Hawaii, which is that the litigant comes in and says, my rights are being violated, and there should be an injunction to prevent that deprivation of my rights. And by the way, others are facing the exact same problem, and for unique reasons. In the particular case, like for immigration, it's because of Article 1's commitment to uniformity, but there's other rationales for other cases. For those unique cases, a nationwide injunction is appropriate. Now, it is the case, as Assistant Attorney General Williams said, that these are pretty rare things historically. And, I do think that is perhaps the best argument on the other side, which is this practice really starts in 1918, then 1963 takes off a little bit more. But I think that there's a couple of points on the other side of that. Number one is, I think this organization knows better than anyone that there's a lot of federal laws out there now that didn't exist for a long period of time because of the expansive commerce power that the government has been asserting since the 1930s. And so it's not surprising that you would have more nationwide injunctions in a period in which the federal government is acting to do more nationwide. And so as the commerce power expands, so too, I think, does the need for some sort of check and balance against that. And those of you who believe in limited government, who are concerned in particular about agency overreach, I think have the most to lose if Professor Harrison's notion is adopted. And indeed, many of the injunctions since 1963, nationwide injunctions, including that one in 1963, was imposed not because of constitutional stuff, but because of administrative law. And so the text of the APA, I think, actually answers this question. It says that a court, quote, must hold unlawful and set aside, end quote, agency action that is unlawful. Set aside the agency action, not just set it aside to that one party, but set it aside more generally. That's 706, Section 706. And the D.C. Circuit has said, quote, when a reviewing court determines that agency regulations are unlawful, the ordinary result is that the rules are vacated, not just that their application to the individual petitioners is prescribed. And to me, that's really the heart of this debate, and certainly was in our litigation of the Hawaii case. The idea that the agency here, the president of the agency, were stepping beyond their bounds, and those rules needed to be vacated, and it didn't make sense to just do it with respect to the parties at hand. Professor Harrison referred to standing doctrine, but I think standing doctrine is very well accommodates for a long, long period of time the idea that these nationwide injunctions are permissible. Because after all, federal judges do issue injunctions to prevent future injuries that are similar to those of the plaintiffs. Think about Hutto versus Finney, in which the court upheld an injunction that prohibited solitary confinement rules, even though and it extended far beyond what the individual litigants were seeking, because they needed a prophylactic protection against something broader. And in cases like NLRB versus Express Publishing Company, the federal courts enjoined defendants from engaging in conduct that could be anticipated to cause harm in the future. You all know the kind of capable of repetition yet evading review doctrine, in which the individual litigant is not suffering harm, but nonetheless, the court says, I can extend relief beyond this individual plaintiff. Next friend standing, another example. And then finally, something that Professor Harrison himself mentioned, the class action system. Because in the class action system, which is the bane of my existence these days, you have all sorts of litigants who are or all sorts of folks who are absent class members and really functionally in a very similar position to non-parties who are benefiting from the relief that is being sought. Now, it's the case that sometimes the class action mechanism can do the work of a nationwide injunction, and for that reason, and to the extent we have any sort of Professor Harrison balancing thing, and I think we're in agreement that that there should be weighing by the court as to whether a nationwide injunction is really necessary. If the class action system is able to do it, then absolutely, it strikes me that that's the appropriate thing. But sometimes the class action system isn't going to work the right way. Think about, for example, something that is very fast moving. Think about version 1 of the travel ban, in which on Friday night the thing is announced. You have chaos at the airports, not just in this country, but worldwide. It would have made no sense, it seems to me, for someone to come in and say, win their case, and then to say, well, you've only won it for you, individual person, every other person has to sue now. That's the most enormous waste of resources imaginable, and I think would fall disproportionately and benefit only certain people and not others. Indeed, we had an example of this in which the judge in Massachusetts enjoined it only for people coming to Logan Airport. And the chaos that resulted as a result of that, as individuals abroad started to switch their flights to Logan Airport and the like, it just doesn't strike me as a smart way to run a system. And that's particularly so, again, in those rare cases when you do have a constitutional command and sometimes a statutory command for uniformity, as you did in the travel ban case. Obviously, Article 1 requiring a uniform rule of naturalization, as well as the 1986 immigration law, which also calls for, it says, quote, the immigration laws of the United States should be enforced vigorously and uniformly. Other times you have circumstances in which the harm that the plaintiff is seeking to remedy spills out beyond the jurisdiction of the individual court, the individual district court. And there it seems to me non-controversial that you should have an injunction that extends beyond the geographic contours of the particular district court. So I think maybe I'll stop there and just answer, or actually raise one thing that Professor Harrison didn't mention, but I do think is a pretty important counter-argument to everything I've said, which is percolation. And the argument goes like this. If you have a nationwide injunction, that freezes the litigation landscape. And so the federal government can't come in and really get that litigated in another circuit or something like that. And the rules about collateral estoppel and stuff, the Supreme Court has said, really the federal government should have the opportunity to litigate in other circuits. And I do think that that is a problem, and one reason why I think nationwide injunctions should be rare. And by the way, I agree with Assistant Attorney General Williams that, that they've gone up to 20 or 27 in the Trump administration. I think that says a lot more about the president than it does about the courts. But I do think that that is a problem, this idea of percolation. I do think that there's, oftentimes there are ways to still get those cases to percolate, the travel ban being a good example in which litigation did ensue in multiple circuits despite the nationwide injunction nature of this. But here's where I'll close. I think that when I ran the Solicitor General's office and we faced nationwide injunctions, we had a pretty easy remedy for that, which was to go to the Supreme Court and get that injunction vacated. And they did so on motions, and they certainly have done so in this administration as well. That strikes me as a tried and true path to creating the type of percolation that I think all of us want to see in appropriate cases. And then sometimes it won't be appropriate and the injunction will remain in place. But to me, that's the better solution. And for, given all of your jubilation about where the court is right now, the Supreme Court, it seems to me actually conservatives have more to lose if Professor Harrison's view is adopted, because you actually do have the ability to get percolation and get these nationwide injunctions lifted, perhaps at a higher frequency rate than might a Democratic president. At least so the argument would go. We'll have to see, but at least that's something that I think we should put on the table.
Okay, thank you. Professor Harrison, you now have 4.5 minutes.
Okay. I used up some of my time. I have 3 half points, and one real point. The first half point is just to stress there are situations in which relief is indivisible, and under those circumstances, the other potential plaintiffs are just going to have to get the benefit whether they think of it as a benefit or not. But striking down a statute, for example, or a regulation, not an example of inherently indivisible relief, or at least not statutes. Second point, just a point of clarification, we talked about this a couple of times. Geography is secondary. The nationwide or not nature of the injunctions is not really the issue. The plaintiff may move around and the defendant may affect the plaintiff all over the place, and so geographically broad injunctions may be just fine. The point about the APA, and in particular the DC Circuit's practice of, as they say, vacating orders, vacating regulations, rests on a particular reading of the APA and a couple of other statutes like the Hobbs Act. One of my projects, when I'm not taking a day off, is going to be to try to track that down and decide whether I think that's right or not, as a matter of reading the statutes. If it is right, I think it's an example of a situation in which Congress has provided a form of relief that is indivisible. If the order is vacated, it's vacated as to everybody by way of giving relief to this particular party. Again, indivisible relief is going to happen. Now the large point. I didn't talk about percolation. I didn't talk about forum shopping. I didn't talk about functional considerations, because when it comes to these fundamental questions about the structure of government, I don't care about percolation or forum shopping or any of these other functional considerations. And not everybody is going to be with me on that. And not everybody on this room is going to be with me on that, because my claim is a fairly radical one, which is, but I will stand by it, which is that it is a condition on the legal legitimacy of what the courts do that they operate within the confines of a structure of government that does not have a council of revision, does not have a European-style Kelsenian court, does not have institutions that can operate directly on the content of the law, has instead common law-style courts that decide cases before them. And they have pluses and minuses when it comes to checking the government. And I urge that the minuses be accepted along with the pluses. The methodological point about that, about how to understand laws and how to understand the Constitution, I think is, to what extent should provisions like Article 3 itself and the whole structure of the way the courts work be understood in light of a purpose attributed to them, say the purpose of reining in the executive and the purpose may require adaptation to change over time, like the expansion in the state, and to what extent should they be understood as being rule-like. And I will say my fundamental commitment on this issue and issues like this is it is always necessary to ask first whether an enactment is a rule. That is to say, something that is to be interpreted formalistically and simply by applying it without asking whether it is fully implementing its purpose. If it is a rule, then you live with its limitations, and it seems to me that these basic features of the system, and in particular, the role of the courts as elaborated in Marbury, is a rule.
Thank you. Now, Mr. Katyal, 7 minutes.
Okay, great. I don't think I'll take the 7 minutes, but I will say a couple of things. Number one, I'm glad Professor Harrison admits this is a radical approach. It is. And, you know, the idea that we would rein the courts in from this really important tool that I think is, particularly in an age of expansive federal government, is, I think, a very dangerous proposition. I actually think that, you know, as we think about the originalist conception of the document, we have to think about how would the founders have reacted to an expansive Congress and an expansive executive that strayed far beyond what they initially envisioned. And would it be that they would have really said, oh, but courts, you have to stay in your lane, exactly where you are. Now, I actually think that nationwide injunctions do follow from the way in which the lane in which courts operated, like bills of peace. They did expand beyond the relief given to the individual parties and expanded more broadly. And since 1918, as I said, we've had federal courts doing this. Now, Professor Harrison says, well, but sometimes relief is indivisible, and in those circumstances, a nationwide injunction would be appropriate, but not in others. But I don't think federal courts have limited them for 100 years. And I think it would be a very dangerous proposition to do so for limited government reasons. And that is why federal courts don't do what Professor Harrison is doing, not just in the nationwide injunction area, but in all sorts of other areas of standing law, like the prophylactic rules they set, like capable of repetition, yet evading review and the like. And so if you adopt this view, you're really adopting a set of views about federal courts that is deeply, deeply stunted, and one that I think is very much in tension with the goal of most people in this room and our founders, which was limited government. The final thing I'll say is about the APA. I happen to be a plain text kind of guy when it comes to statutory interpretation. The text is as plain as day, that this is what federal courts are empowered to do: set aside agency action more broadly, invalidated as a whole, when an individual litigant comes before. And so that relief extends more broadly. Now, Professor Harrison is right to say this is authorized by Congress, and so maybe that makes it different. But the big debate over nationwide injunctions happens to be largely around APA cases. And so at least for, I don't know the exact numbers, but of that list of 27, many of those are APA cases. You know, don't think of the overall number count when you think about whether this is legitimate or not. And then the last thing I'd say is, you know, the fact that Congress has provided it here in the APA context doesn't mean that they have to do so elsewhere, some sort of exclusio unius principle or something like that. It very well may be an example of the power that federal courts have historically had in this realm. So thanks. It's been a pleasure debating with you.
Great. So now we'll have some more general give and take, and then we'll open it up to questions. One question I had for you, Professor Harrison, is Mr. Katyal right that the better originalist argument is for courts to have this power, that the founders would have wanted a greater check on government action and not to have it should lean against government action rather than allowing it to go forward?
Well, the word originalist is, of course, a dangerous one, and one reason.
You're telling me.
And one reason it's dangerous is because it frequently leads to the kind of inquiry that I think Neal's in favor of and that I'm against. which is, what are the purposes, and how would people who had these purposes have wanted the structure to adapt to changing situations? And I think first, I think it is extremely difficult to answer questions like that. And one reason I'm not that kind of originalist, to the extent I'm an originalist, is because I think it is extremely difficult to answer questions of the form, okay, had they known all these things that have happened in the succeeding 200 years, how would those particular people have thought about this? Well, they wouldn't be those particular people anymore if they knew the next 200 years of history. I do think that the rule structure that they gave us operates the way I described it, and it does have a place for things like bills of peace, but that those have to be representative actions, and again, that's implemented through class actions. And yes, if the Federal Convention reconvened in 2019, what would they do? I don't know. I do know, I think it would be an excellent idea to have a new Federal Convention now, but it would be run by us and not by the people from the 18th century.
So, Mr. Katyal, why aren't class actions sufficient? You know, Rule 23 is there for a reason. It provides protection. It provides a lot of requirements, as you know, to certify a class. Aren't those protections there for a reason? And aren't you subverting them if you're not using the class action in only unique cases?
Yeah, so first let me just say a word about method. You know, I think Professor Harrison's right to say it's difficult to understand and answer the question, what would the founders have thought about X in today's age? But I think, as my colleague Randy Barnett has pointed out, Randy's right there, it's also hard to ask the questions that we're dealing with on a sub-constitutional level. You know, is founding practice about bills of equity the same as what nationwide injunctions are? You have these, you know, deep translation questions, both in, not just in constitutional law, but all throughout the law. I'm not sure necessarily that they're any more difficult in one than the other. Now, with respect to class actions, look, I think these are nationwide injunctions when imposed in the rare circumstances, like the travel ban, are effectively representation actions. So they follow directly from the tradition of the bills of peace. And oftentimes they can be used and should be used. And indeed, when a court is thinking about, is this the rare circumstance in which a nationwide injunction is appropriate, I think you're absolutely right. They have to ask as one of their very first questions, why isn't this a class action? But in a case like the travel ban, the reason would be twofold. Number one, fast-moving emergency situation in which it would be kind of impractical and very hard to actually certify a class within the time period necessary in order to give relief to the parties. Literally, plane tickets are bought and people are at the airport. And you have a constitutional command that says that immigration law has to be done uniformly. So in a circumstance like that, it's actually, to me, in tension with the Constitution and the original understanding of it to allow a court to do something and slice and dice up what immigration law would look like.
So, Professor Harrison, is Mr. Katyal right? He's raised several times the APA and the set-aside language. Do you think that's a correct reading of the APA, that Congress intended for set-aside to extend beyond the parties, and that should, by extension, apply beyond the APA?
Two things. First, as I said, I'm not sure. And one of the reasons I'm not sure, and people have written this about this a little bit in this connection, is the APA and the remedial structure that it created was, at the time it was adopted, largely aimed at adjudications. Rulemaking was substantially less common then than it is now. And exactly how the different provisions of the APA and similar statutes operate with respect to rules, I think, is a question that has to be answered. Some of those words certainly sound like set aside. That's something a court does with the award of an arbitrator, for example. That sounds like it's adjudicatory, and that's the sort of the body of questions I would want to look at that I just don't know the answers to. Mm-hmm. The other thing I will say about the APA is that if it means that, then it is a congressionally mandated form of indivisible relief, which operates on an entire administrative decision. Essentially, what the court is doing is ordering the agency to rescind the entire act that it undertook. Indivisible relief is not intrinsically unconstitutional. If Congress decides they want it, they can have it. The thing I will say is that where relief is necessarily divisible, then it goes beyond the authority of the courts to grant it to somebody who's not a plaintiff.
So, Mr. Katyal, how do you respond to concerns that universal injunctions are a one-way ratchet? So for the government, the ACLU brings 10 cases in forums that it likes, and the government has to win in every single case in order to prevail, but the ACLU has to only win in one case, for example.
Great. So, and before doing that, just on the text of the APA, I mean, literally, this is the plain text, that they, quote, hold unlawful and set aside agency action. It doesn't say courts are empowered to set aside agency adjudications. And obviously, the whole structure of the APA is agencies do two things. They make rules and they adjudicate cases. And obviously, both are encompassed within the term agency action, just on the plain text. Look, the one-way ratchet is, I think, a problem. It's the kind of doppelganger of the percolation problem. And it does impose extra burdens on the federal government, as I certainly know well. At the same time, I think that's actually the burden the federal government should have. Again, not in every case. I think these should be done really rarely. But when you have a federal government that is so powerful, that is so capable of taking away people's rights, I think they should at least temporarily have to run the table. They can always go to the Supreme Court or to the Court of Appeals first to try and get the injunction lifted. But ultimately, it strikes me as that's the right way to do it. And again, these emergency cases are ones where there's a constitutional command for uniformity or something like that.
So what about this argument that you can always go to the Supreme Court? Is that sufficient to say, well, the government can just ask for relief from a nationwide injunction if they go to the Supreme Court?
Well, again, that's a functional consideration, and so in commenting on it, I'm sort of this is gravy. I'm going beyond what I primarily want to say, but the answer is not necessarily. That is one remedy, but the Supreme Court has a lot going on. So it's certainly not unheard of for them to have for the Supreme Court to have more than one emergency, the situation before it, and to say, oh yeah, any time there's a real problem with a fire in this town, we can just dynamite all the buildings right around where the fire is. Yes, there are solutions, but that's a costly and frequently as a functional matter, a costly and I think often an unnecessary solution. That kind of burden shouldn't be put on a single institution that has a lot going on.
So the proposition, though, is not any time there's a fire. It's any time that there's a rare fire.
Rare fire. All right, we now have 15 minutes, so we'll open it up to questions. And I saw Professor Calabrese up first, so go ahead.
Thank you. My question is primarily for Professor Harrison, but also for Professor Katyal. And I wanted to talk a little bit about the history of injunctive relief. And to do that, I wanted to mention something about English courts as well as the American history of injunctive relief. In England, from the 12th century until 1492, there were three common law courts: the Court of King's Bench, the Court of Common Pleas, and the Court of Exchequer. Of those courts, only the Court of King's Bench could issue writs of mandamus. When Henry VII became king in 1492, he created three equity courts: the Court of Star Chamber, the Court of High Commission, which heard ecclesiastical cases, and the Court of Chancery, which heard ordinary equitable cases. In 1641, the Court of Star Chamber was abolished because it had been abusive. The Court of High Commission was also abolished. The only equity court surviving when the framers wrote the Constitution in 1787 was the Court of Chancery, and that was the only court you could get an injunction from. To get a writ of mandamus in England, you had to go to the Court of King's Bench. In 1837 or so, the U.S. Supreme Court decided Kendall against Stokes et al. And in that case, Congress had by statute prescribed that a certain number of mail carriers be paid by Amos Kendall, who was the Postmaster General to Andrew Jackson, a sum of money which they claimed they were due. Kendall refused to pay the money. Stokes, on behalf of the people, went to the court and sought a writ of mandamus from the lower court. The court issued the writ of mandamus, and then in the Supreme Court, the issue was, do all the federal courts in the country have the power to issue writs of mandamus and injunctions, or is this a special power which could only be exercised by the Court of King's Bench in England, which could only be exercised by a federal court of chancery? And the court found that all the courts in the country were courts of equity, and all the courts in the country could issue injunctions and writs of mandamus. That takes us up to the Lochner period. And after Lochner, progressives became very concerned about court injunctions because they were often used to break strikes. So the progressives established what was called a three-judge district court, and only three-judge district courts could adopt injunctions, and this was to prevent the abuse of injunctions, which the progressives thought the Lochner-era judges were engaging in. In 1975, the post-Watergate Congress repealed that act because they wanted single district judges to enjoin civil rights violations, and they wanted to make it easier to get injunctions. So today, three-judge district courts only remain for voting rights cases. If you have a single judge able to issue an injunction, not only can that apply nationwide, but it also means that a single district judge in California can stop the governor and the state legislature of California from doing something that they want to do. Shouldn't we go back to the system of having three-judge courts to issue injunctions, the system that we had from the Lochner era up until the Democrats repealed it for civil rights reasons in the 1970s? You know, equity is good, and a court of chancery is good, and writs of mandamus and injunctions have their place, but the broad history of both English and American law is that mostly that power has been limited in some way or another, and the nationwide injunctions being issued right now are not limitations of that kind.
Yeah, when I started thinking about this, one of the things I thought about was whether to suggest something like that, because there's legislation been introduced in Congress specifically about this problem, and one of the questions is a reform like that returning to the days of the three-judge district court. And the reason I didn't say anything about that is because I genuinely don't know what I think about that as an administrative reform. There is something to be said for it. This kind of relief, and again, I think the important part is not the nationwide character, it's the as to all potential plaintiffs character. That's the real issue here. There is something to be said for that, but the country's experience with three-judge district courts has not altogether been happy, in part because whenever there's a rule about having three-judge district courts, those rules have to be administered, and those rules further complicate the litigation. Back when there were three-judge district courts, there would be long preliminary debates about whether this really should go to the three-judge district court. Sometimes part of a case went to one judge and the other part went to a three-judge court, and that's another reason that Congress got rid of that system. And so, without giving the matter substantially more thought, I wouldn't say anything other than that's an option that should be on the agenda, but we have to bear in mind there's a body of experience that shows that it has pluses and minuses.
And just to add to that, there's a real practical problem. I've litigated in three-judge courts, for example, in voting rights cases in which that still exists. I'm not sure the law still exists anymore, but the three-judge court, the problem with that is when you have a three-judge court, it goes directly to the Supreme Court. There's actually only 2 levels there, not 3. Right. And for those of you who are concerned about nationwide injunctions, actually it might be better, the current system, because right now it's district court, then it immediately goes to the circuit court within seconds, basically. The district court's asked to stay their injunction. If they deny, then the Solicitor General just authorizes an appeal pretty much on a rocket docket, and within a few hours that appeal arrives at the circuit court. So better, it seems to me, to have actually 4 lower court judges, which is the current system, deciding this, a district court judge and then 3 Court of Appeals judges, than to only have 3.
one could have three-judge district courts with an appeal going to the Court of Appeals and then to the Supreme Court. All of this would require new legislation.
Exactly.
Okay. Is that Professor Barnett?
Yes. Believe it or not, Steve Calabrese asked the exact same question I was going to ask.
I have never heard Randy so quiet.
I think you're next.
I think maybe it goes to that side before it comes back to
Oh,
me,
okay. If we're
or
gonna count that one.
it's up to you to decide.
Sure, well, go ahead. I think you were saying.
Maybe the issue of who should go to a three-judge district
Yeah,
court,
three-judge
perhaps.
district court.
But until we convene,
See how long it takes with three?
until we convene such a court, I will go ahead and ask my question, which is primarily for John Harrison, but Neal Katyal is always welcome to comment as well. And that is, if I understand your argument correctly, and if I don't, certainly tell me why I don't, it's actually fine to have, or was fine to have, a wide range of nationwide injunctions or universal injunctions during the period when you could have the bills of peace, but now that's been displaced by class actions, and class actions are the only mechanisms. So that, I think, raises an issue or two. One is it really the case that class actions have displaced bills of peace, or maybe they've given an alternative mechanism by which you can get nationwide injunctions, but also get a number of other things which are unique to class actions. And the other is that if it is the case, as you suggest, that the bills of peace injunctions were permissible because they were representational, but being representational doesn't require any actual agreement by these other parties that the party before the court will represent their interests, and so forth, then it seems like a pretty thin notion of what's representational that would also, again, allow a pretty wide range of universal injunction cases, probably, I think, in nearly all the situations where Neal Katyal would want them to exist, that is, cases where there is a broad-ranging policy with many potential plaintiffs who are similarly situated. So if that is the case, it seems like maybe your argument ultimately leads in a direction that's much closer to your opponents than may seem at first sight.
Yeah, here's what I think about bills of peace, based on my current knowledge of that, and there's always more to know about historical things like this, that they were understood as being genuinely representational, that the courts would conduct at least some inquiry into the commonality of interest of the plaintiffs who were not present. So it seems to me, first point is that requirement that there be genuine representation is meaningful, and it was understood to be meaningful then. It should be understood to be meaningful now insofar as this is part of Article 3. And the other thing I want to say is, yes, I do think class actions have other functions, but I do think they have, in effect, they have displaced anything other than the class action that would operate on the justification that it is representative. What Congress and the court have done is say, yes, it's possible to have a representative action, and this is what it looks like. It is a class action. So they have occupied all of that space, and they've occupied other space too, but they've occupied all of the space with the class action. One of the good things about having the class action, I think, is, I'll admit, the concept of a representative action as we can discern it in history, as I say, I think it's meaningful. It is a somewhat amorphous idea. Just how representative does it have to be? Just how much do the interests of the absent plaintiffs have to be consulted? One good thing, I believe in rules, one good thing about the class action mechanism is that it takes that relatively amorphous concept and makes it significantly more specific and requires particular inquiries into, well, what are the circumstances under which one party can genuinely be said to represent another?
I guess I'd say two things. Number one is that Professor Harrison says that that he thinks that under the bills of peace there was a true inquiry into the representational nature. I'm not sure of that. I've read a little bit about this. I understand there was an inquiry into whether others are similarly situated in the bills of peace, but that seems to me very similar to what happens in these nationwide injunctions too. In those rare circumstances in which they should be imposed, it seems to me one of the questions is that necessary? Is there some group of people at airports around the world or something that can't effectively get relief in one place or another. Then the second thing I'd say is I do think your question really does underscore one of the tensions in this argument. Oh, we can just use class actions. We don't need nationwide injunctions. Class actions have many of the same problems. I know Professor Harrison isn't as focused on that, but others are. Percolation, asymmetric effects to the government. I mean, if I win a class action injunction in district court, I mean, I only need to win one in any particular jurisdiction, and then nationwide, the government's hands are tied, and there won't be percolation in other circuits absent a lifting of the injunction by the United States Supreme Court on emergency relief. So it seems to me the class action has the same kind of policy problems that do nationwide injunctions.
Over here.
Two short questions. First, if Professor Katyal's right about the meaning of the APA, doesn't that make universal injunctions mandatory in every single case, challenging agency rules or agency actions, and then doesn't that in turn undercut your claim that universal injunctions should be rare? Second, why can't courts presume that agency rules are severable as applied to every discrete litigant and every discrete circumstance? Normally, courts presume that statutes are severable in that way, unless it's an abortion case. So why shouldn't the same presumption carry over to agency rules? And if your argument seems to presume agency rules should be regarded as non-severable, but I think that presumption needs to be justified and not simply assumed.
So I don't think they can be severable just because of the text of the APA. Sometimes, you have a severability clause or something like that. Here you really do have 706 saying, quote, the reviewing court shall hold unlawful and set aside agency action found to be in excess of jurisdiction or contravening a constitutional right or whatever. That's a very good point, that I do think that, if you can prove up to a court that the agency action is unlawful, then it would follow from the text of the statute that it has to be set aside.
Let me add one thing about that. Whatever you think about severability in some other possible context, some APA challenges, like for example a failure to go through notice and comment, are the kind of thing that operate at the level of the rule.
So my question is for Mr. Katyal, and basically it is your version of percolation really percolation? It seems to me that you have exactly the same problem that you've identified in many other circumstances where agencies, including such things as the IRS, may get an opinion they don't like in one particular circuit or district court, and they will accede to it in just that place. But they also have to make a decision. Do we accede to it in just that place or nationwide? And that becomes, therefore, an administrative decision. So your version of this puts the court in charge of deciding whether it's going to be nationwide and takes it away from the administration, number one. And number two, I always thought that the whole policy argument about percolation was to give the Supreme Court a more developed view of what was going on. Is it really percolation to leave it up to one court to decide and give only one judges, or perhaps another version that you suggested is the district court and the circuit court for that particular area, to have it developed only to that degree and not allow the Supreme Court to have the same issue developed more thoroughly and have a more thoroughly developed record before? So at least those two aspects. Is your version of percolation really percolation?
Right, okay, so I might have used too much shorthand and might not have been clear enough as to what I'm saying. So first of all, I think percolation is a big problem with nationwide injunctions. Second, I think that when the Supreme Court avenue I'm talking about is a way to let 1,000 flowers bloom. So the way it works is, say, I don't know, the Ninth Circuit enjoins something that the president is doing. Then you can or the district court in the Ninth Circuit, and then it goes to the Ninth Circuit. They say, yeah, that's absolutely fine over a dissent, but it goes. Then the Solicitor General has the option of going right to the Supreme Court and saying, please dissolve this injunction. If they dissolve the injunction It's not like it's just now the Ninth Circuit is the only ballgame. It now means that that action will go into effect everywhere else because the government believes what they're doing is lawful. And so they will seek to enforce it in all the other circuits. Litigation, the 10 ACLU lawsuits will then be brought in all of those other circuits. And then you will have percolation through that mechanism. And so you have effectively a blank slate for the courts of appeals on which to rule and to tee up a case then for the United States Supreme Court. And look, I don't think this is ideal in any circumstance, in almost any circumstance, but there are those rare circumstances when it is effectively the second best option, because otherwise you are dealing with the immediate deprivation of rights from people who otherwise can't sue, who can't get their rights protected through the class action mechanism, and it may contravene a constitutional command like uniformity.
I think we have time for one more question.
First question is, should it be, I'm not like Mr. Calabrese, I'm not that knowledgeable, but I think there's a reasonable concern about having a district court judge from really anywhere constrain the President of the United States. And so one of my things is, do you think it would be prudent that an appeal has to be found and won at the Supreme Court level before the executive of the United States is constrained, number one? And number two, shouldn't we be considering this as not only negative injunctions, but also affirmative injunctions? Imagine if a district judge has an affirmative injunction that applies to everybody across the board. And how does this impact the equation? I think it's reasonable to consider that. And if you could, I'd appreciate it.
So any such notion of an affirmative injunction just seems to me ridiculous on its own terms. That's not a problem with nationwide injunctions. That's a problem with the injunction itself. And any court that deigned to impose such a thing, as you're suggesting, it would be the easiest thing in the world for any Solicitor General to get that lifted by the Court of Appeals. So that strikes me as a non-problem. Now look, you could say the Supreme Court is the only one that can effectively carry out its relief when there's unconstitutional or unlawful action being taken. There's a couple problems with that. One, it would contravene the text of the APA. But number two, I think it would really contravene our constitutional structure. I mean, presidents can do all sorts of indelible, dangerous, anti-constitutional, unconstitutional things, and it takes a while to get a case up to the Supreme Court. So that strikes me, again, from the principle of so many of you in this room, a principle rooted in limited government, a very dangerous thing to just say you've got to get all the way up to the Supreme Court before your relief has any purchase.
I largely agree with that. Everything I said about running three-judge district courts like this, I guess, multiplied at least by 3 or maybe cubed if it's the Supreme Court of the United States where there are 9 of them and they're known to have strong views about issues. And the actual original jurisdiction of the Supreme Court is by design quite narrow. There's a reason we have this entire federal judicial system. So considering that as sort of a policy suggestion, I have doubts about three-judge district courts. And I think one point on which we disagree, the less the Supreme Court of the United States is called on in these situations, I think as a policy matter, the better for the country.
Well, thank you so much. I know Mr. Katyal has a hard stop at 2:15, so we're going to end a little early. But thank you so much to both of you for being here, for giving your thoughts. This is a really live issue in the courts, so it'll be interesting to watch it over this term and over the next couple of terms. Thank you.